will be listed, but please little bit patient. We are listing all matters. I'm trying to also get the information also. So first fresh admission, then orders, then after notice. And whenever after notice old matters are there, please cooperate for completion of the hearing. I mean, not in your case. I'm just in general. I'm saying requesting. Yes.
In the list, item number 22,
Yes.
I have filed a memo for withdrawal.
Kindly file the mail.
File kochi ba?
It is on record. It is on record.
Record.
Okay. Yes. Noted.
Item 18.
22 sorry. आप 22 रे नाम तो
Agya?
सेटा तो डिफेक्ट रिमूव पे
अरे 22 mention है अपन 22 किस कोई बात नहीं तो
no.
Anyone appearing for the other side in 22? ठीक है. Yes, noted. Flag B.
Mala item.
Yes.
Again?
It is at flag B.
Mala
Item 18.
Yes.
Page 1, 1 to 6.
item 33, my lord.
6.
My lord, page 1, my lord.
7 to 19.
Item 18, my lord.
हाँ.
Defect remove पे रही चीज़ सफा था.
18 टा posting कर दो तो.
Not rule commencing, not.
9 ही विक्री ऐसी वाले. Correct. Yes.
Page 3, 22, 25.
22 टा गला. 20 रू 25. Yes. Next, please.
Page 4, 26 to 28.
27.
27. Yes.
Aswan it after Asu star out.
Posting कर देंगे. 27.
Not rule commencing.
Interim order.
No order is passed. It will not be touched. Interim order remains untouched. We are taking advantage of this computerized posting. So that's saving time also. Like by simply passing orders and signing it takes time. Yes. Next, please.
Page 5, 29 to 35.
My lord, item 33, my lord.
Whenever a serial is there, just give him.
My lord,
33, sir. Posting. You want a date? A date कर दियो तो
Rule commencing, 16.
33 बार there, madam.
अच्छा.
Okay. कितने कहले?
16.
16 week.
Item 30, my lord.
Yes, please.
Lord, I have
30.
filed my Vakalatnama along with senior appeals memo on 27, but our name has not been reflected.
So that judicial order has to be passed. अपन कहाँ पे appear कर चुके?
Opposite party number 2, Civil Supply Corporation.
OP2, Civil Supply Corporation. Samir Misra, sir. Samir Misra.
Vigyan Kumar Sharma is
Vigyan
appearing.
Sharma.
Appearance memo on filed.
अपन कौन है?
Rudra Vishek Sahoo.
You are writing RA or R Sahoo?
Arsa.
Okay. When did you file Okalat?
27 January 2026.
Today is? No, it will not be tagged. Okay. Yes.
Still prefer an adjournment.
Yes. If it reaches, it will be adjourned because today I have a truncated day. So unfortunate
Obliged.
passing on. Yes, Mr. Ray.
My lord, item 38, next page.
Next page. Okay.
Item 38.
Sir, ଆପଣ call କରୁନାହାନ୍ତି?
Page 6, 36 to 39.
38, my lord. I am for the opposite party. I am filing the counter affidavit today.
No
I have
possibility of amicable settlement. Sarvakshama, that Abhijan.
Amnesty scheme
Amnesty.
letter has not come to the petition. Otherwise,
Send it.
again,
Send amnesty letters to all.
If it will be
That will be a
amendable.
great achievement, sir.
Yes, my lord.
Sir, these are in the nature of compliances,
Yes, my lord.
where the statutory compliances are to be made. Of course, the rigor of the statute has to be, that is how it has been made penal. Otherwise, compliance will be difficult. It's not enforced. But you have a discussion.
Yes, my lord.
Tell the view of the court and the Supreme Court that we should go for this kind of amnesty.
There is a scheme going on.
Yes. Same to everyone.
Yes, my lord.
Yes.
They are trying.
Mr. Ray, what is happening? Suppose we are sending about 10,000. Non-responsive is 30,000. That would happen to you also.
Yes,
Maybe, the non-responsive is 5,000-6,000.
yes.
No one is coming up. But if 4,000 are coming up out of 10,000, then that's a great achievement.
Yes. Absolutely.
My lord, item 37.
I have received the copy of the counter, my lord. If necessary, I'll be filing a short.
You are filing it counter today.
Yes, ma'am.
So in the registry.
Yes.
How much? It will be adjourned by 4 weeks.
Yeah, I'll file the
Yes,
if necessary.
Basically.
Entry
Full
model.
comments.
Entry model also.
23-26,
Yeah.
we commencing.
Entry model.
Interim order to continue. I'll pass that order. Yes.
Chief, sir.
My lord, item 37, I am for the petitioner.
Yes. Yes.
If it may come any other day, if possible, my lord.
Other side kindly inform. Have you informed the other side?
No, my lord, I have not informed. I don't know his number, so I could
You
not.
have to get from the bar association directory
My
or
lord,
from the Wakalatnama.
I will inform.
37 टा post कर दियो तो
We commencing 16.
16
16.
we commencing 16
Obliged, my lord.
yes.
Item 1.
May I please, Your sir.
Yes, please.
The answer 3 page 20, the judgment dated 16/2/2023 is under challenge of lordship,
Yes, please.
but the 125 application of the wife is allowed. The present petition is the husband, and they have awarded only 2,000 per month, Your lordship. The case of the petitioner that since long they married, and they both they are in the old age lordship. Now the husband is 70, around 73, and wife is around 70. And the husband was working as a peon in the collectorate Cuttack, and retired since 2009, and now getting the
Any case law on this regarding age of the husband being 70 years?
No,
And
my
after
lord.
retirement as a peon in the collectorate, 125 will not be applicable.
No, my lord. That is
So how can I direct the magistrate to pass a wrong order?
no, my lord.
So you were not expected, Mr. Boral, you have private sufficient. Let us make strong legally nuanced discussion. You can, I mean, always you can bring, these are persuasive factors.
Yes,
So that is how, even if his pension would be 20,000, award is 2,000. Because you have success convinced the law, court that he's a old man, he's all these things. These are persuasive.
yes,
But if the court will base its reasoning on these factors, then 125 is not actually, there is no such scope.
Yes,
154. Same parameter.
so far the award is concerned 2,000, that is not higher lordship. Only material lordship on record that the wife driven out the husband from his native original village lordship, and she is residing there in the house and enjoying all the properties, everything. And
The place, thankfully, the court has not inquired into the place of residence of the husband. How happy or how unhappy he is, where he stays now.
that
It is anybody's guess.
has been taken into consideration by the trial court lordship. And
So that is how he has so many liabilities where he
Yes.
stays now. There he has to give money or not. He is not a vagrant. Is he a vagabond who's moving around? He's not a vagrant.
no.
He is happy to stay somewhere with enjoying all his life. And you know, Mr. Biswal, when the own house is given to the lady, I mean the wife, the better half, in what circumstances? So he could have easily driven out the lady at the age of 70. She should have moved around with a begging.
Since long lordship. Suffering from old age disease lordship. That is
No case. No case.
the permitted to withdrawals. Kind of.
Mr. Sushanta Kumar Borala for the petitioner. Opposite party, blank. The petitioner husband in the marriage is before this court challenging the order passed by the learned judge, Family Court Cuttack. Stuff. By the said judgment dated 16/2/2023, the learned judge, Family Court, Cuttack, has allowed the petition filed under section 125 of the CRPC, 1973, into bracket, since repealed, by the wife in the marriage, claiming monthly maintenance. The learned counsel for the petitioner, learned counsel for the petitioner, upon perusal of the judgment rendered by the learned family court, this court is of the view that the judgment does not suffer from any illegality or irregularity. The relevant aspects considered. Relevant aspects, material on record, as well as evidence adduced,
Yes.
as well as evidence adduced, have been considered in their proper perspective. The issues framed are correct and have been answered in accordance with law. It is also noticed that the opposite party wife in the marriage is 67 years and the petitioner husband is aged about 69 years. Stop. The opposite party had prayed for an amount of rupees 5,000 per month towards their maintenance. Considering all the relevant aspects, the learned court has directed for grant of maintenance of rupees 2,000 per month from the date of application, that is 8/2/2013. That judgment by the division bench of Justice Deepak Gupta and Aniruddha Bose. ठीक है, ऊपर है। सीधा सीधा रहना है, कौन लिखे? At this stage, the learned counsel for the petitioner files memo of date, memo of date stating that the petitioner would not pursue the present petition. But accordingly, the petition stands disposed of. Yes, please.
Item to my lord. My lord, may I permit, my lord?
Mr. Singh, you are appearing through mobile phone in a small window. What is this?
No, my
You are not using even computer also. Are you sure the Zoom platform will be supported by a mobile phone? Can you see me?
yes, my lord. Yes, my lord. I am seeing.
Yes.
My lord.
Yes, submit.
My lord, in this case, on last date, your lordship made a question to me whether this read petition is maintainable or not against the order passed under section 24 of the Hindu Marriage Act, my lord.
Right, sir.
Yes, my lord. On that issue, my lord, I have point out, my lord.
Sir, you have to come to argue, sir. Please come to court on some other day. The petitioner, the learned counsel for the petitioner has some difficulty to present in court and appears in VC. He shall, the matter is adjourned to enable him to appear physically. Ko tarikh kebe asle hobo, sir?
Any day, your lordship. Any day, your lordship.
In the week commencing, Dui,
Again.
Dui, 26.
Again. Oblige.
Yes.
Item 3.
That matters also to procure the custom milling matters.
Yes.
There matters the
Mr. Misra is not available.
My learned senior is in BC, your lordship.
Okay.
matters
ଟିକେ allow କରନ୍ତୁ SK ଯୋଉ ଲେଖା ହେଇଛନ୍ତି ସମୀର କୁମାର ମିଶ୍ର ହଁ ସେଇ ତାକୁ allow କରନ୍ତୁ ତା ଉପରେ ଲାଷ୍ଟ ଲାଷ୍ଟ ବଟ୍ ୱାନ୍ ଏ ଆପଣ ଆଣନ୍ତୁ ଭିଡିଓ ଅଫ୍ ରହିଥିବ ସେଥିରେ କ'ଣ ଅଛି ଆପଣ ତାକୁ allow ଆପଣ ପିନ୍ କରନ୍ତୁ ତାଙ୍କ ସ୍କ୍ରିନ୍ ଟାକୁ ପିନ୍ କରିଦିଅନ୍ତୁ ହଁ kindly unmute Mr. Misra. Samir Misra, kindly unmute.
My lord.
Any instruction?
matters my learned friend filed a counter, very bulky counter. Of course, whatever they stated, that is what I have already stated in my writ petition. I have also got a counter copy yesterday, matters filed by the opposite party number 1 and 2 government.
But that copy, in fact, has not been given to me.
Huh?
My friend is there.
Lenka, anything positive? I will not interfere with that order.
Positive means
Positive in the negativity. Positive in all the negativity. Philosophical.
negative.
All darkness and negative.
Yes.
So then it has to be hard. So
No,
Which is just to add. That's the only thing matters may point out.
you file. You want to report anything? You file your result.
That I will file a result, sir.
His main prayer, my lord seniors, main prayer is to consider his representation.
Consider his
That is the.
But willingness.
No, Mr. Lenka. To consider representation, I will be most happy because my scoring rate increases.
Now we have, in the meantime, we have
Appreciate one thing. So I gave you a platform to play 2020.
Yes.
So that you can quickly come here.
Yes, we have.
And also, Mr. Mahapatra is also regretting because the 2 lines I have stated the stringent conditions and all that. So he might be thinking that Mr. Das going somewhere that yeah. So because what will come, I have left it open to you also.
And if your lordship will
Because the
go,
language used in my order is, they submitted that present petitioner is awaiting adjudication in the proceedings against him and he is yet to be found guilty and any violation of any violations.
Yes.
And only 6 indulgence of the authorities to comply with all the norms with utmost sincerity and to the stringency that would be imposed by the authority. So this was not his language. No lawyer will concede this. But obviously to encourage both of you, but to give you a platform,
there is a
fast scoring wicket, so I had added these slides.
FIR is under section 7 of the EC Act.
Correct.
That is generally not compoundable.
Not compoundable.
That is pending. And if your lordship will go
Sir, not compoundable, and there is no presumption of culpability, nor I will add to that. We are making a statement, make it complete because we are discussing law. Is it in EC Act 7?
Yes.
The onus of proving he has to prove himself innocent, like some other cases, PMLA and all these things.
the burden of proof lies on the
Prosecution.
Yes.
So that
And another
so
aspect,
since that I did not. I mean,
then another aspect is
that is the reason. That is the reason in the appeal. In the appeal in this OPDS control order, the executive authority, appellate authority, ADM has been given power to suspend that. Because here it is maybe a miller is a bigger person, but OPDS dealer is a smaller person who will lose everything. That is how. Must understand the legislative intent.
Then
Why before during adjudication also If he is found guilty, then you may provide capital punishment for EC Act. That's a different thing. Or a life imprisonment, or beyond 7 years or 10 years, no difficulty. But sir, now we are discussing, at least the court cannot presume, much less the authority.
And yeah, another aspect your lordship, if your lordship will go to the annex of
Sir, Mr. Lenka placing the counter, to be all fairness, he has received it, he will file his
No, there is appeal provision. We have rejected
Here in this
similar case.
My friend also gave a copy to me so that
against the order of the collector.
Yes, yes, yes.
my friend may give a copy
submit
to
the-
us so that there can be a reconciled submission.
I request my brother kind of wet one. So far as that procurement of paddy, government framed a guideline. These guidelines kind of glass to 18.3. So
And the passing on of documents, there is a problem because
because you are there in that side, I will serve a copy. But I think you will not dispute that guideline, much knowing about that guideline.
it's not a question of disputing, it is assisting properly.
He will not know whatever.
That exactly. Thing is that I can visualize one thing. What Miles already pointed out, Miles, I am on that. First, Miles,
You can read it aloud so that he.
So 8.3 Miles.
18.3
Miles.
Okay, start with 18.
Participation of existing custom miller came 2025 and 26. The default millers who subsequently clear the defaulted amount in full can participate in the custom milling if otherwise found eligible with approval of the such and such officers. However, the miller will be treated as a new miller for all KMS if otherwise found eligible. That is, it is to be left. It is to lift paddy in 1:1 SD. One is the total value. SD norms only in all KMS to come. 1:1.
No, then again it is on merit, Mr. Mahapatra. Then what would be the connotation of default? So now one more resolution is necessary for printing it in correct English. Default miller doesn't make neither here nor there. So maybe defaulted millers. Declared default. Defaulters. It can be defaulters or defaulted. So defaulter, whether would include a person against whom this EC Act case is pending. So that would be the matter of argument.
That is what.
But your point is well taken, that you are saying there is a possibility even in case of default. They are allowing clear the defaulted amount. So
in this case, I am not defaulted in payment or in delivery. The whole total guideline is that default minus that guideline dealt with. Of course, I have given a portion of that because this is the whole total guideline. There, they categorically stated that.
Mr. Mahapatra, you have made your efforts. We have created a situation where they can act. Because rather very stringent words used by the same.
That I agreed.
So they still they will argue on merit. So let us leave it there now. Let's hope for the best. But something may happen. Yes.
Then I may think is that processing is going on. Next week, in the meanwhile, I will filing regenter so that can hear.
Not next week. We commencing 9th.
We commencing 9th.
Serve on them.
I hope my learned senior has abandoned the idea of amendment. Last occasion he was saying he will amend.
No, say what they say. I have requested to allot me that the collector has rejected. After minors passed an order on the same day evening, that rejection order has been passed.
You want to challenge that rejection order also?
Obviously, minors were to bring it.
So amendment is there or not? Already there?
I got it from this counter only.
Okay. Mr. Dayananda Mahapatra, Senior Advocate. Instructed by Mr.
P.K. Singh.
Mr. Arya Das is there?
Yes.
Your old hand. One of the esteemed senior judges told him Arji or Arya, so I still remember. That is how I remember his name. Mr. J. Barik, Mr. R. Pradhan, sorry. Ponti likhi de dev P.K. Singh Dev. Mr. P.K. Singh Dev and Mr. Arya Das for the petition. Mr. D.N. Lenka, learned AGA. For OPs 1 and 3. Mr. Samir Misra, senior advocate, along with S. Sahoo, Ms. S. Sahoo for the OP number 214. The learned senior advocate for the petitioner refers to the order dated 21/1/2026, paragraph 3. Hello? Stop. In response, it is submitted by the learned DG that he has filed his counter. It is also submitted by the learned counsel, Mr. Misra, for the OP number 214 that he has filed his counter. Copy of the counter affidavits filed on behalf of OP number 1 and 3 as well as 2 and 4 have been served.
2 and 4 we have
served,
given.
I
I have not been served with the copy filed by 1.
Served on the learned instructing counsel appearing for the petitioner. Copy of the counter filed by the OP number 1 and 3 shall be served on Ms. Sahoo appearing for the learned instructing counsel for OP number 2 and 4. Ms. Sahoo, you have received you have served on Mr. Lenka?
Yes, we have given, my lord.
Okay. Ms. Sahoo submits that she has already served. Maybe the file lagi nathibo. She has already served the copy of the counter on OP number 1 and 3. Copy of the counter served Korea pen lek hai na. Copy of the counter filed by OP 1 and 3 shall be served on Ms. Sahoo. Eta purbo sentence. Bisi udah gala to apna confuse hoiyo. Shall be served, right. Yes. It is submitted para. It is submitted by the learned senior advocate for the petitioner that the collector OP number OP number 3 has rejected the representation.
No, representation rejection no. More option देइथिली जे I will
rejected the prayer for allotment of milling of rice. Allotment of paddy.
Allotment of paddy
Custom CMS or CMR, custom milling of rice. The said prayer has been rejected as would be evident from annexer. Annexer 9.
Annexer J/4 to the counter.
Annexer J/4
series to the
J4 series to the counter filed by
OP 1
OP number 1, 3 and 4. He seeks leave to amend the present writ petition if so advised. Prayer is allowed. The petitioner, if so advised, shall amend the writ amend the writ application. List in the week commencing 9/2/2026. 16/2 will be I have some difficulty. 23/2 ହେଇପାରିବ 9 ନହେଲେ 23.
No,
ଠିକ ଅଛି 9/2.
Item 4.
And Mr. Lenka and Mr. Misra has left. A person who has been bitten once will be shy for the second time. That is a rule of nature. This person will never in his lifetime as a custom miller for the another unless greed overtakes him. He will not never show any misdemeanor because he's within your completely within your clutch now. He's in the back foot. Anyway, that is more philosophy than if you define it within the perimeters of law or parameters of law, it's not you. But if you give him a chance.
There is legal barrier.
Correct.
No legal barrier, my lord.
Unless it is compoundable, it will
not compoundable.
Sir, can you?
It is an adjudicator process, my lord, compounding.
Where suppose let us I accept your submission.
Yes.
I'll record that.
Yes.
Since it is not a compoundable offense.
Section 7.
So is it a correct order I will be passing? I will not pass those wrong orders. How I am concerned, he'll be if he is punished. Can I give imprimatur that he will now show that before the trial court? or he will challenge him. So I will not pass those orders. Whether compoundable, whether he will be hanged or punished for 7 years, it is his fate and his the question of trial. How effectively you conduct trial as a prosecutor. This is something else. This is something else, mister. This is the writ petition is regarding the activity of custom milling. Correct. It is not that he was in your service. He has been arrested for 48 hours, so he has been suspended. That is the service condition. And if you do not initiate any DP, a person who has been convicted of any crime and he is acquitted, what is the natural consequence? Consequence is reinstatement. The reason being, you cannot sit in appeal over a competent court's judgment, acquitting a person. So the High Court will not make that mistake. If I will start adjudicating whether it is compoundable or not, whether it is a heinous crime or not, I will not never go there. Why should I?
And that too, my limited period is.
Your instructing officers have gone in the wrong direction. They have not been asked whether to exonerate him or to certify him that he is the most honest custom miller. That is not their job. They may be in hand in glove. That is another thing. But they will not ask, I will not, why should I enter into that arena when it is a matter of trial? Yes.
Item 4.
Posting कर देना है ठीक है.
Item 5.
এটা বোধহয় মেনশন করলে না কোন? ঠিক আছে, পোস্টিং করতে হবে.
Item 6.
Five.
May please, Lordship.
तेरा नहीं है सुन तू? Justice Bose's decision. Yes.
In item number 5, my dear.
You are Mr.
Abhijit Manti.
A. Hassan.
No, no. I am in item number 5, my lord.
Five. What's your name, sir?
A. Manti.
A. Mahanti. So A. Mahanti for the petitioner. Yes.
And for the statement.
Mr. D. N. Lenka, AG for the state.
My lord, here the present transfer petition has been filed for transfer of Barampur Cyber PS case number. In Barampur, 2 cases are pending.
Case law will guide this.
My lord?
You straight away come to the case law, which I will apply to direct transfer.
As for under 6.
Tell me the FIR, where the FIR was lost.
FIR was lost on Barampur, my lord.
Yes.
First of all.
So then, charge sheet has been filed, final form.
Final form has been filed also in
Where?
Barampur, my lord.
So then,
only one possible only, my just land.
no, today there is a truncated hearing. If we keep on piling up the adjourning the matters passing over, then we cannot complete the list.
My lord.
So ଆପଣ ଆଉ ଗୋଟେ ଦିନକୁ prepare ହେଇକି ଆସନ୍ତୁ.
Just now my senior is.
The other day also he took Passover and whole day.
He's just outside, he's just coming.
नहीं ठीक ଅଛି sir. No issue sir.
Just come.
May I permit to speak?
Yes please. You have been waiting sir.
There is.
Prabhat Chandra Jena petitioner. Yes.
I pray in this application for transfer of 4 other cases from the different district to Bhubaneswar.
Where is the occurrence occurred?
The occurrence will see.
Place of occurrence, FIR, date. Yes. You prepare a chart so that because it is a narrative of kind of a essay that every line contains some details.
Recorded.
How many cases he is accused?
6 cases now, Your Lordship.
6 cases.
6 cases.
What kind of offense he committed?
All are similar 420, Your Lordship.
What kind, sir? Cyber crime, or why this economic offense is there?
The economic, I am an employee of a company, Your Lordship.
Collected money.
Collected money. I have not been collected. Money collected by the company. Allegation against me that I allowed the depositor to deposit the money of the company, so the company returned the money with higher rate of interest
Where
rates.
the FIRs have been lost.
FIR has been lodged in different places, Your Lordship. The
So the value person who has deposited, he will be facing difficulty.
The Supreme Court judgment is there, Your Lordship.
Which judgment? That in these kind of cases it has to be transferred.
One will say Rabindra Singh Sidhu, Your Lordship.
Which paragraph? Citation first.
This was filed in writ petition criminal, Your Lordship. And the paragraph 19.
Citation, sir. Citation.
I would not okay that issue Jeros Kennedy. Sorry, but I have no extra copy. I have a single copy. I am supplying, Your Lordship.
I have all the this. I am asking you the citation. I never uttered the word copy.
Yes, yes, ma'am. This is writ petition criminal number 394 2024.
Citation.
2025 INSC 727.
25 INSC
727.
Patina.
Rabindra Singh Sidhu versus State of Punjab and others. And another one, Your Lordship.
Sir, you are not having copies. Court is assisting you to find out the case. So please, you have to have patience. Ravindra, R-I-V-I-N-D-R-A.
R-I-V-N-D-E-R. Ravinder Singh Sidhu.
ଏଠି ଆଣିଲେ ସ୍କ୍ରିନରେ INSC ରୁ ଆଣନ୍ତୁ RIVINDER अरे तो जेना भी अटेंटिव आपण कोन
VINDER
हां
Ravinder Singh Sidhu
SINGH
SINGH
Sidhu spelling
SIDHU versus State of Punjab and others.
It is a case of people collecting money from people.
Yes, economic offense, Lordship.
No, not economic offense. Question is very specific. Did Ravinder Singh collect money from different people at different places? No, China, God. ठीक है स्लोली जानते रही जाते इनके स्क्रोल कले पढ़ी होनी बड़ा पढ़ुच तो काइंडली रीड द फर्स्ट 3 lines.
Yes, ma'am. The present petition has been filed.
Slowly पढ़िए. Has been filed seeking to issue an appropriate writ. Kindly read, sir. Read, sir. So don't read.
Direction for clubbing and transporting the multiple first terms report.
Stop there. You are seeking transfer of FIR or the cases pending trial?
Cases pending trial.
So it has to be. The learned counsel for the petitioner relies on the petition has been filed by the petitioner against whom several trials are pending. At before different courts throughout the state, as indicated in the cause title of the petition. Hard learned counsel for the petitioner. ऊपर को जान scroll क्या आती है ऊपर जाते हाँ he relies on the decision of the Honorable Apex Court, Honorable Supreme Court rendered in judgment relies on judgment of the Honorable Supreme Court rendered in Ravinder Singh Sidhu RIVINDER SINGH space SIDHU versus the state of Punjab and others. Pull down, pull down. This paragraph 1 of the said judgment indicates the writ petition was filed before the Hon'Ble before the Apex Court for issuance of direction for clubbing and transferring the multiple fast information reports registered against the petitioner in different states. सेठी देखा जाउची एटा सेपट देखा जीवन different states to the court of competent jurisdiction at Panchkula, Haryana. The present application has been filed by the petitioner seeking transfer of trials to a particular court. Accordingly, stop. In view of the judgment relied upon, not being at all applicable to the facts of this case, the Lord Counsel for the petitioner has adjournment. We commencing?
Another judgment is there. I have another judgment. That is so far.
It's not applicable. That's of the case. Yes. The reliance of the petitioner on the decision rendered in Rabinder Singh Sidhu is of no avail. The citation document, sir.
This is your lordship. The citation has not been given reference, but the writ petition criminal number is given for and there is Supreme Court judgment.
AI generated, there is a risk. The problem is, if you do not give a citation, it is no judgment for a court. Now, after the advent of AI, AI is unable to read it.
The only case number has been given in lordship. The writ petition criminal number 40/22.
Without citation, case take up Korean. The other,
that I may be verified some other day, lordship.
Rabinder Singh
Rabinder Singh judgment so far the FIR clubbing part is concerned and so far the Abhishek
dictation sala pare apna kagaj bodu bhi na. The Lord Counsel for the refers to a decision which he says he cannot supply the provide the citation. Who take a decision?
Supreme Court judgment.
Supreme Court judgment. Don't answer.
Writ petition criminal number 40/2020.
मते बढ़ान आपण RAV कहले ने RAB कह देले सर जड़ा भूल हैला.
This is regarding trial errors.
Bill application.
And they both same both clubbing and trial both
मते ठीक समय लगे एटा पढिया पे तरे किछि डायरेक्शन नै क्लबिंग करिया पे
both are there lordship.
अरे both are there that थरा कहले मु कोन कहले
The findings are both.
Mr. Jena, I am not saying both are not there. This is regarding grant of bail.
I would know
which paragraph you are saying that the Supreme Court directed.
I pray relatively some other day tomorrow.
You are so busy, you are not hearing the order.
Monday,
last time, the Lord Counsel for the petitioner has adjournment. I asked you that when do you want? About Sunil night. The Lord Counsel for the petitioner
Tuesday.
Tuesday, simply possible. Today it has to be disposed of. Effective and substantial hearing. The realize of the decision of the order passed by the Honorable Supreme Court dated 13/7/2022. In Abhishek Singh Chauhan versus Union of India. colon देखी दिता बिंदु read petition into bracket criminal number 40 of 2022. अरे paragraph उड़ी जाएगा. Regarding regarding the said decision, it is submitted that the citation has not been obtained. However, it is apparent at page 4 of the said decision that the apex court directed clubbing off of all the FIRs state-wise. Against से कहले जे वेस्ट बेंगल राजस्थान महाराष्ट्र जोड़ी जाथिबो this simply follows that. But clubbing off of FIR state-wise. अरे सीटा रख दी. Paper लिखी the Lord Counsel for the petitioner 6 and has adjournment list in the week commencing. Page 2 2026.
Obligings.
Item 6.
किससे पर अप्रोच कॉल करते ना तो ताले पोस्टिंग कर दियो एटा रखी देले स्टी यस प्रिंट कर देबे रविंदर सी दर्शन अच्छा ठीक है यस मिस्टर दळी अरे आपण
May I please?
Mr. Vishwaranjan Dali for the
Filed an application
Yes.
for transfer of GR case number. GR case number from the JMH Civil Judge Junior Division Kujang to ADJM Puri minor. The background of the case is that minor. Initially, the case was tried before the Civil Judge Junior Division Kujang.
और जोड़ा अर्जन को पोस्टिंग करी ना लास्ट रे करछोंदी है नहीं अरे कौन अपन तो सुनिबे नहीं किछ ओई तो से नॉट I am asking you something else. Usually आपण लास्ट रे करछोंदी ना एबे करछोंदी तार आंसर वी कमेंसिंग नॉट दुई नहीं फॉर देख से तो आगुआ कर दोछु आप पूर्व मैटर मिस्टर डीएन लेके आईटी अपीयरेंस में हां ठीक है इट हाउस आइटम 7 yes come background yes Mr. Dal.
The background of the case is that my trial was commenced before the Civil Judge Junior Division Kujang. Thereafter, after examination of some witnesses, they transferred to JMFCP Kujang. Thereafter, again transferred JMFCP Kujang to Civil Judge Junior Division Kujang now pending pending before the Civil Judge Junior Division Kujang minor. In the meantime, two civil proceedings related to family court matters are pending before the Judge Family Court Puri minor. And
Initiated by whom?
That is the opposite part number 2 minor informant in file a divorce and present petition.
Puri रे कोटा की फाइल करछन
Puri re both file petitioner number 1 file करछि Puri re for execution of conjugal life and informant file करछि for divorce. And that
जो कुजोगा मैटर टा की फाइल कर
that is the opposite part number 2. He is the informant minor. What?
को प्रोविजन रे
That is GR case number minor.
अरे जी आर नुह आ गया गवर्नमेंट रिकॉर्ड पचने पड़ो जनक ना रे केस फाइल हेछि आपण कोर्ट को आछचंदी को दफा रे केस फाइल हेछि
498
तला कहि सेटा केते समय लागु छै खोली के बाहर करियो पड़ो 490 ऑकरेंस कोठी
at the jurisdiction of Kujang minor.
then which decision now Mr. Jena cited
No, what
wonderful decisions of closing of affairs
in the meantime
in 498A when the lady files a complaint in Kujanga, the occurrence is at torture is at Kujanga. So he has to be acquitted at Kujanga or to be acquitted at Puri after trial.
That is the original jurisdiction of
So show some citation on that, sir. Don't make me vulnerable.
During course
You have to assist because somebody commits a crime, suppose.
No, that is the original jurisdiction that can be trial before the
Sir, how can I apply it to a matrimonial proceeding?
No, madam, that is not, madam. But in the meantime, what happened during trial, my lord?
For 498A,
That is
it's the rarest of, and that too when the complainant is a lady. And actually, you are arguing against yourself. She belongs to Puri.
CG now working as a Satsanga Puri under the district of Puri, my lord.
Sir, I said Puri, you are saying Satsanga Puri.
Yeah.
So my answer, your answer has to be yes. Satsanga Puri or ye apankara some other place in Puri, how does it make a difference?
Yes.
But she cannot prosecute the matter at Puri. Is it not? For convenience of the complainant also, it has to be at Puri.
In the meantime, all the independent witnesses examined, my lord, except.
So you want delaying the trial?
No, my lord. What
So
happened, my lord?
then how another court will facilitate it? I am unable to actually understand. Whatever little understanding I have of these criminal trials and proceedings.
And present petitioner belongs to Bhubaneswar, my lord.
He may belong to Moon also. Is it relevant for the court to decide? Commits somebody coming from Moon in the space shuttle commits a crime at Kujanga. Then why the trial would happen?
That is also trial.
So you have to examine the law, sir. Tell me the jurisprudence. That whenever the person thinks that it will be at Bhubaneswar, he feels Jagat Singhpur or some other place, there is some law on this.
The back behind of the present petitioner and the council's, my lord. Some dates are changed and NBW issued against the present petitioner, my lord, by the local councils, my lord. For they are facing a lot of.
NBW, sir, NBW was issued, when it is issued, I know, sir. Long back before I started practice.
And petitioner 2 is the.
This is really bad news. So what do you say, Mr. Dole?
Not proceed the application. Observe giving observe the Ajano record by non code below.
No, that unnecessary loose talk is possible in court. I can. Like just now I talked about the incident in Bokaro when I visited. So, but that's not passing judicial hurdles becomes very difficult. You have made your effort and you have very fairly tossed all the aspects. Mr. Vishwaranjan Dale for the petitioner. You take your seat, both of you. I'll take some time. Take your seat. Vishwaranjan Dale for the petitioner. Mr. D.N. Lenka for the OP number 1. The petitioner has approached this court seeking transfer of GR number 1031 of 2023, arising out of Kujanga PS case number 390 of 2023. Commitment है नहीं?
Tribunal magistrate trial.
Magistrate tribunal.
Yes, ma'am.
कौन लिखा? Take your seat. On being asked, it is fairly submitted by the learned counsel for the petitioner that alleged occurrence took place in Kujanga. Accordingly, the matter is proceeding before the JMFC Kujanga. After arguing for some time, the memo on behalf of the petitioner is filed indicating therein that the petitioner doesn't want to place this petition. Memo is taken on record. The petition starts post up. Yes, next.
Item 8. May I please, Lord, sir.
Mr. Rautre. Mr. Binay Bhushan Rautre for the petitioner.
My lord, the petitioner wife has filed this TRPC application to transfer from the Court of Learned Civil Judge Senior Division Hindol to the Court of Learned Judge Family Court Bhadrak, my lord. My lord, other 2 proceedings are pending in the Court of Learned Judge Bhadrak Family Court and one is pending in the Court of HGM Bhadrak, my lord.
Where the lady resides?
Bhadrak, my lord. My lord, the petitioner wife is suffering from breast cancer, my lord. Now she is under treatment, my lord.
If you want this section 9 application from Hindol
My
to be
lord.
transferred,
My lord.
the petitioner wife is before this court seeking transfer of matrimonial case number 10 of 2025, pending before the learned judge, before the learned civil judge, senior division Hindol, to the court of jurisdiction at
Learned Judge Family Court Bhadrak.
to the court of learned judge family court Bhadrak. The petition, the cause title of the petition, copy of the petition enclosed. Cause title of the copy of petition filed before the civil judge senior division Indore indicates the petitioner, the opposite party therein, wife in the marriage, stays at her father's house at village Purnahat, PS Bhattapada, post Bhattapada, village Purnahat, post Bhattapada, PS PED, district Bhadrak. It is submitted that the petitioner is also suffering from ailments, which further makes it difficult for her to appear and attend the case at Onugul, the Hindor. HINDOL. Para, I should notice along with this order. Stop, para. Requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 5 working days. List after SR, liberty to mention. IA number 6 of 2026, hard learned counsel for the petitioner. Upper that you selected, hard learned counsel. IA 6 of 2026, hard learned counsel for the petitioner. Issue notice as above. Stop, para. Accept one set of process fee as well as postal requisites along with the petition. In the ऊपर जो लिख ले returnable date fix कर दिया तो issue notice जो लिख ले नहीं तब requisites भी file तापर add करूँ तो returnable date अधिक ते 38 तारीख returnable date be fixed to 27/2/2026 तापर लिखिए next जो आईए लिखते हैं in the interim it is directed that upon a prayer being made for adjournment of the pending CP, MAT case, MAT case number 10 of 2025, the Lorded Court in session of the matter at Hindor shall adjourn the same beyond 16th of March 2026 as per convenience of the court. List in the week commencing 9/3/2026. Ordinance certified copy as per rules? Yes, next.
Item 9.
Mr. Santosh Kumar Samantray for the petitioner.
My lord.
Yes, Mr. Samantray.
My lord, in a matrimonial suit initiated under Section 13 of the Hindu Marriage Act
By
the wife, opposite party, judgment was allowed in her favor, allowing.
Judgment was the microphone on nahi.
My lord, yes, this matrimonial suit was allowed in favor of the wife.
Correct.
Decree of divorce is granted.
Yes.
And permanent alimony of rupees 6 lakhs is awarded in her favor. And
Yes.
thereafter, she filed an execution proceeding.
Yes.
It is execution proceeding number 3/2023.
Yes.
Wherein I filed an application that during process of this execution case, she had already married another, and she has already begotten a girl child.
and that is why in view of section 25 subsection.
But have you challenged the decree?
Well, that decree is subject matter of challenge in appeal, and
So
that,
there you have to move.
that appeal is pending.
Parallel proceedings cannot be. So the execution is subject matter of the appeal.
My lord.
Cannot be the writ petition.
No, I do
That is my
understand.
understanding.
But that execution proceedings should not have been continued.
No, you are
during
getting the
pendency
point,
appeal.
sir.
My lord.
Sir said should not have been continued is advisory. Please appreciate. Good things, so many good things we expect, it is not then the lawyers will be eliminated actually. These things should happen, which should have happened is not happened. So he has come to a lawyer, but lawyer should not come to the read court to take, because it is already a subject matter. The decree which is being executed is subject matter in appeal of the MATA.
Appeal.
So how can I take
I challenge the executability of the decree.
there?
My lord, I challenge that application was dismissed. That is why I came before this.
Dismiss can show the dismissal order
My lord.
in the MATA.
That is at annexure 6, page 49. My lord, this is not
Possible and required.
no, sir, 49.
MATA High Court order. MATA jurisdiction court asila. Civil Judge Senior Division Bhajanagar.
Again, that matrimonial suit was pending there. That is why execution proceeding is.
ଆପଣଙ୍କର appeal जो file କରିଛନ୍ତି ଥର କହିଲେ ମୁଁ ଯେତେବେଳେ ପଚାରିଲେ ଆପଣ ସେ କାହିଁ ସେ order କାହିଁ division bench କୋଉଠି reject କଲେ ଆପଣଙ୍କ prayer for stay of execution.
That is, my lord, annexure 6, page 49.
ମୋର ମିଶୁନି ଆଜ୍ଞା ଏଟା High Court ଲେଖା ହେଇନି.
Sorry, my lord.
ମୁଁ ଆଉ ଗୋଟେ file ଧରିଛି କି?
My Pavitra Kumar Pradhan.
ନାଇଁ 1548 ତ ମୁଁ ଠିକ ଖୋଲିଛି. So I hope you understood the sequence what I asked you.
My lord.
That the decree passed by the Lorette court granting permanent alimony
My lord.
is under challenge by you.
Yes.
So there what has happened? The decree has been stayed or the decree has been, what has happened there?
No, my lord. That appeal is pending still.
So what happened to the decree? Has it been stayed?
No. I file an application in the decretal court that.
Sir, do you then, I never asked you what you did in the
Your
decretal
Lordship,
court.
kindly allow me to say. No, sir, I will clarify. So execution da jout hella.
ନାଇଁ ନାଇଁ ଆପଣ ଓଡ଼ିଆରେ କୁହନ୍ତୁନି ମୁଁ ଇଂଲିଶ ଭଲ ବୁଝିପାରୁଛି ଟିକେ ଷ୍ଟାଣ୍ଡାର୍ଡ ଅଛି ଇଂଲିଶରେ
Yes, sir.
ମୋର ଅସୁବିଧା ହେଉଛି ମୁଁ ଇଂଲିଶରେ ଯାହା କହୁଛି ଆପଣ
No,
ବୁଝିପାରୁନାହାନ୍ତି
that is my.
I'm asking you.
No, that is my.
After you got a decree, now there are you are decree holder has two decrees. One is 125 decree, one is section 25 decree.
No.
No. Then tell
Here, my lord, section 13 is jota hella judgment.
13 decree when 25 decree.
That is, man, I am not saying about.
I said 25, you said no. You are saying 13. 13 is a decree for divorce.
So that is why I am saying, my lord.
Sir, please don't say that. Whether an amount has been awarded as permanent alimony under section 25 or not.
Well, that can be conjointly allowed in section 13 application also.
You are not getting, sir.
Well, in section 13.
Sir, I know that much of law as you are erudite. I am not there. Whether the wife is having a decree of permanent alimony or not.
Yes.
Yes. So what happened to that decree?
That decree was subject matter of execution before that court. In that execution proceeding, I filed objection, saying that once
permanent alimony execution decree has been filed.
Yes. Yes.
Permanent alimony.
Again.
So kindly then you have challenged that permanent alimony order in MATA.
MATA.
Correct.
Yes.
So what happened in MATA?
MATA is pending.
So what order is there regarding that decree passed in MATA?
Well, no order has been passed. That has not been decided. That is still pending.
I understood, sir. What is the order passed? During pendency of the matter.
During pendency of the matter, in execution case.
MATA re kon hela?
Sir, MATA re kisi hai.
Obsessed with execution.
Sir, MATA.
Sir. You have not moved.
Sir, appeal is pending consideration.
If appeal is pending consideration, what happens to the upon jota ko exception no chandi seta 25 no 13, but my little understanding it is 25. So jo 25 jota hela apankar 25 re apana challenge kahi stay no nanti. Why you are not moving the appellate court? Why you have come?
That is correct, my lord.
That is correct, sir. What I say is cannot be correct. So it is a matter of procedure. It is not my speech which will be to be correct. आपण जदि चैलेंज इफ यू हैव चैलेंज द सेक्शन 13 रेड विथ 25 आपण जा कंजॉइंट कोन कहउचंदी कंजॉइंट डिक्री it cannot be attributed to 25.
No.
Which law in
My lord, in section 30.
which case law says that the permanent alimony is not 25? Which Supreme Court has said?
My lord, I never said so.
You never said, then kindly you have to see the replay. It is available in YouTube also. Because you must understand what you are saying, I reflect in my order. That is how the analysis. If I say direct this, there is a conjoint decree under section 13 granting alimony, then I have to, I must sound logical. Our discussion is legal nuance discussion. Then in MATL you have not moved. Okay. MATL number, page 14.
Page 39, Annexure 3.
That appeal, nothing has happened. You have not moved original decree granting you permanent alimony. Ordering portion.
And that appeal memo, this is appeal memo.
Page 37 dekho. 36. You look at page 36.
36, yes. The matrimonial case is decreed on contest against the respondent and further circumstances without any cause. Therefore, the marriage of the petitioner with the respondent is dissolved by a decree of divorce with effect from the decree. Further, the respondent is directed to pay payment of alimony rupees 6 lakhs the petitioner.
Payment of alimony. The word is not matching. You are reading something else.
Payment alimony.
Read again, 36 last line.
Yeah.
Further, the respondent
is directed to pay permanent alimony.
So that you are saying is not 25.
That is 25. Permanent alimony. Permanent alimony of rupees 6 lakhs.
Go to page 17, last 3 lines.
17.
34. Internal page 17.
17.
Last 5 lines.
Yes. Therefore, it is most.
Again, it is not matching.
Separate.
Apan ko brief page 34 अच्छी.
Page 34 अच्छी.
Internal page 17 से अच्छी. That is internal page 17 of the judgment.
Again, 34.
Last 4-5 lines.
Last 4-5 lines. The affidavit of assets and liability.
I request you to read it, sir. Complete.
The affidavit of assets and liability have been filed by both the parties. OPW1 has admitted about passing of interim maintenance order of rupees 3,000 per month in favor of PW1 in MC case number 30/2017 by JMFC Buguda and non-compliance of such order by him. OPW1 has shown his monthly income of rupees 8,000 after deduction of loan of rupees 7,000, 1,200, 102 rupees.
Can you read again, sir?
Rupees 7 lakh 12,000, 102 bank loan and hand loan of rupees 5 lakhs. He claims to be paying installments of rupees 15,600 per month for bank loan and has also mentioned about medical expenses of his parents. Exhibit D is the X-ray report of OPW1's mother. OPW1 has filed relevant documents regarding the loans availed by him and interests thereon from bank. But he has not filed his salary bills, although it was required in the affidavit of assets and liabilities. During cross-examination of OPW1 has contradicted from his own version.
The OPW1 has contradicted
from his own version that he is employed in private sector, whereas it is clearly evident that he is employed in a government school as an assistant teacher. OPW1 has further contended that PW1 is getting a monthly income of rupees 20 to 30,000 from tailoring business, but has not adduced any evidence to substantiate it. PW1 has denied about such contentions. It also transfers from Exhibit 4 that OPW1 had filed MAT case number 10/2020 before Senior Civil Judge Kodala, claiming institution of conjugal rights, wherein he has reflected the profession of PW1 as household duties. So the version of OPW1 in two different forums and in two different cases are not same. Therefore, such contentions is rejected. While deciding the quantum of maintenance, it would not be appropriate, inappropriate to take note of the fact that PW1 is not alone. Rather, the daughter of the parties is also staying with her. So PW1 has been facing the challenges to meet the expenses.
So leave it there. Now you mark the quality of evidence for our side and your contradictory statements. So then this decree has been satisfied, 4 lakhs or whatever. What amount?
My lord,
have you satisfied 6 lakhs?
my lord, I have not satisfied. Reason being,
So what is on the challenge here?
That is, my lord, your lordship may kindly see annexure 4, page 45.
Yes.
That the execution petition is filed by the decree holder.
Yes.
Saying that this amount may be released in her favor by attaching the salary of judgment debtor. I filed my objection.
Which amount? This, when you are saying this, that, please be specific.
My lord.
Which amount? The decretal amount in the...
The 6 lakhs.
No case made out. No case made out.
Thereafter, I filed my objection at page 47, saying that she has already married to another person.
Sir, when then read, sir, because you are avoiding to read 25, that is also the problem.
Yeah.
Can you read 25?
Any court exercising jurisdiction under this act may at
Bit slowly.
I guess. Any court exercising jurisdiction under this act may at the time of passing any decree or at any time subsequent thereto an application made to it for the purpose of either the wife or the husband.
Should I go to 2 actually?
Sir.
2 you have to return.
2. If the court is satisfied that there is a change in the circumstances of either party to any time after it has made an order under subsection 1, it may at the instance of either party vary, modify or rescind any such order in such manner in the court.
So why 25(2) is provided?
Sir, my lord, may kindly see.
Sorry, sir. ଆପଣ ଟିକେ ମାଇକ୍ରୋଫୋନ ଟା ଦେଲେ ଆପଣ ଅଧା କଥା ମୁଁ ଶୁଣି ପାରୁଛି ଆପଣ କାନ ଫାନ କହୁଛନ୍ତି କି
ନାଇଁ
କଥା ଆପଣଙ୍କୁ ଶୁଭୁଛି ମାଇଲଟ କଣ କହୁଛି ମାଇଲଟ
my petition comes under sub rule 3.
ସେଟା ତ ଠିକ ଅଛି ଆପଣ 25(2) ଫାଇଲ କରିଥିଲେ କି
sir ମୁଁ ଯୋଉ objection ଟା ଫାଇଲ କରିଥିଲି it is in the shape of this petition.
ନାଇଁ 25(2) ଫାଇଲ କରିଥିଲେ କି
ନାଇଁ sir ମୁଁ ଫାଇଲ କରିନି.
Correct, ଠିକ ଅଛି.
My application in the shape of section 25 subsection 3.
Yes.
Because I have mentioned
ତାପରେ 3 ପଢନ୍ତୁ 3 ଫାଇଲ କରିଛନ୍ତି 3 ଫାଇଲ କରିଛନ୍ତି
ନାଇଁ sir ମୁଁ 3 ଫାଇଲ କରିନି.
ଠିକ ଅଛି 3 ପଢୁନାହାନ୍ତି.
If the court is satisfied that the party in whose favor an order has been made under this section has remarried, or if such party is the wife, that she has not remained chaste, or if
ସେଇଟା
sir
ସେଇଟା ଠିକ ଅଛି ସେଇଟା ଆପଣ ତାପରେ ଆପଣ 3 ଟା ମାନେ ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ନା 2 ସାଙ୍ଗରେ ପଢା ହେବ 1 ସାଙ୍ଗରେ ପଢା ହେବ
sir ସେଇଟା 1
ସାଙ୍ଗରେ ପଢା ହେବ
ନାଇଁ ସବଜେକ୍ଟ ଟୁ
2 ସାଙ୍ଗରେ ପଢା ହେବ
ପଢା
ଆପଣ ଆସ୍ତେ କହୁଛନ୍ତି ମତେ ବହୁତ ଜିନିଷ ଶୁଭୁନି ଆପଣ 2 ଟା କଣ କହୁଛନ୍ତି 2 ଟା କଣ ହେବ ରିଟର୍ନ 3 ଟା ଯୋଉ କହୁଛନ୍ତି ଆପଣ 3 ଟା କଣ 3 ଅବଜେକ୍ସନ ଫାଇଲ କରୁଛନ୍ତି ଅବଜେକ୍ସନ ତ କିଛି ନାହିଁ 3 ରେ
ଯଦି ସେ ସବସିକ୍ୱେଣ୍ଟଲି ମ୍ୟାରେଡ୍ ହେଲା
ଯଦି ଆପଣ ଓଡିଆ ବୁଝିବା ଦରକାର ନାହିଁ
ଆଜ୍ଞା
you have not filed in 3 you are saying that your objection is 25(3) so that so no case why 25(3) said objection be treated as obviously you have to say that
then I will...
So what is the date of marriage? So second marriage of the lady you have alleged in the petition.
My lord,
objection.
My lord, may kindly see annexure 8, page 54.
Objection starts at page 47, not 54.
She ଲେଖିଦେଇଛି she has already married କିନ୍ତୁ ଡେଟ୍ ମୁଁ ଲେଖା ହେଇନି
paragraph
ଆଜ୍ଞା
page 48 para 6 ପଢନ୍ତୁ
ଆଜ୍ଞା
don't waste time in turning pages. Page
Para
46.
6. Para 6. Further, in the meantime, the decree holder is already married to another person and leading happy conjugal life with him.
Birth of child?
That is Annexure 8, RTI.
No, in the application. You have stated in the application you have said
No,
that.
not in application.
You have not stated.
No, no.
The court will know how the court will know the factum of marriage, date of marriage to arrive at 25-3,
And that is correct.
25-2.
My lord, I may be
Because 25-3 and 25-2 are subsequent events.
So I will file a better petition. Mention.
No. No merit, sir. And kindly read this.
Aye.
Supreme Court judgment. Para 3. Kindly read it aloud for me also.
We are constrained to observe that this order shows total non-application of mind on the part of the High Court. This was a case where maintenance had been granted to a wife and to a minor son. The High Court, without recording any reason whatsoever, has stayed the grant of maintenance both to the wife and to the minor son. This should not be done. A husband, father is duty bound to maintain his wife and child unless there are very special reasons. The High Court should not normally stay such an order. In the present case, no reason has been mentioned justifying the grant of the stay.
So kindly get it back. And please mark the strong words used by the Supreme Court in an interim order. It is unusual. This is interim order. The Supreme Court could have very well said that you go before the court and say for vacation of interim order.
My lord, may I pray one thing, my lord?
Sir, whatever you pray, you have consumed my time, so I have to spend my time in dictating the order. I would request you, just you take your seat, I will dictate the order. Yes. Whatever, I mean, definitely it is not that I will pass the order prejudicing without, So whatever, after I dictate the order, you make your submissions, whatever you want. Now, anything else on merits, or you are satisfied with your submission? You want anything to say further?
My lord, only my humble submission before this honorable court. If all those things have not been mentioned, I will be allowed to.
Sir, this is not, round robin like our today's cricket. Come back after some time also if you want, but I will dictate after I reach. Yes. Other matters which will not right to reach because of the proceeding. Sorry, sir. I don't know.
Out of station,
No, please. But I'll record your submissions. Yes. And the last submission that you will be allowed to repair that pleadings that you are saying that I will not record. Because if I record, I have to reject. Oh, well, very well. Sir, all other matters where we can, maybe possibly will not be able to reach because of the, full court reference. So, yes. So you take dates and I'll continue at least.
Rest of the matter next week.
Not next week. It will be distributed fast, fresh and orders, then sir, afterwards.
But those will come.
Definitely. Definitely, I'm trying to ensure and he seems to be scared of doing that.
I have a small request to my lord.
Yes, please.
What item number 12 is there?
Yes.
Where the
12 I will reach, sir, I think. Because I think now I am at 9.
I'm rest assured.
But after recess 12, I hopefully yes. This will take little time because so many points have been argued by Mr.
I thought your lordship will not.
No, Samantra has argued so many points. The younger Mr. S.K. Samantra. So
Yes.
I have to record those.
I was told that your lordship may not resume after lunch because of the cricket match or something like that. Now that your lordship will resume, I am rest assured.
No, cricket match. Yes. लाइन टा आपनकर सर्च लाइन टा खाली डिक्टेशन रहला और दर तो डकियो ना
Item 10.
Mr. Ravi Narayan Mahanti. Mr. Ravi Narayan Mahanti for the petitioner.
Also, petitioner wife of the opposite party, let's see, and petition opposite party have filed a CP proceeding number 30/2025 before the family judge Bhubaneswar, and as per the Hindu Minor Guardianship Act Section 6, let's see, for interim custody of the minor child of the both petitioner and the opposite party, and the child age was, let's see, 5 years, and order has been passed, let's see, on 12/2025. And in this order, let's see, and the director of the family judge.
Sir, can we have a brief discussion because we are having very little time? Only there is a pending dictation to be made for a rather a longish order. So you are challenging the vegetation and
challenge the order, let's see, annexure 8, let's see, annexure 5.
Sir, I'm aware, sir. You are challenging. I'm saying that brief discussion on the law.
Yes, let's see.
Sir, when in which condition? The father, natural guardian.
Biological guardian.
I'm asking.
Yes,
If you answer, then you complete, then I will start discussing. So you are the model challenges, and in our time, there are very strict and stern judges.
Yes.
Somebody chewing and keeping pan inside mouth and submitting in court, really scared of.
No, I'm not chewing the pan.
Hopefully. And the great Justice R.K. Patra will say that go and wash your face and come back.
No, never.
Same thing, Koutule.
That order has been passed, and the people will.
So you are agreed by the condition. You are agreed by the condition.
I have challenged this condition, let's see. People will one Sunday in between 11 a.m. to 1 p.m. let's see. In a week, so that time.
So what was your suggestion before the learned trial court regarding the timing and all this? Because you see, this is not the job of an appellate court.
Yes, yes.
If I have understood you correctly, thanks for. I mean, I interjected, but you have cooperated also. That you are not agreed with the vegetation and contact right of the father.
No, that I am not.
So you are regarding this condition to be modified to your inconvenience.
Yes.
What you have stated before the learned trial court. Kindly show that.
Because I'm in my.
Sir, it cannot be a matter of speech. It has to be a pleading.
Yes, my objection I have completely denied to because I'm denied. So as per the
Sir, I'm not there, sir. You are very fairly saying that though you registered the contact and vegetation right of a father with he is a minor child,
yes.
But regarding the time and the interval, you are agreed.
Yes, sir.
So what was your state before the learned trial court?
I'm not challenging that. I'm not filing any petition before the learned court.
And how this court, appellate court, will presume, sir?
Because that is the order has already been passed.
You must understand that litigations should not take time. A matter which is to be taken up by the trial court, here actually you are taking, and it will spend more time in issuing notice, sufficiency of notice, pleadings, counter, all
the counter when the matter has been pending before.
Sir, which counter?
The counter,
sir, listening to me, sir. Mr. Blanti.
Annexure 4, page 7.
So you are not listening, sir.
Yeah.
In a fresh matter, why can you annex the counter at annexure 4? I am saying a matter to be taken up by the court which had allowed vegetation and contact right, the timing and all these things. There are finer aspects of that. So it has to be considered by that court only.
So let's give me liberty, let's file.
I mean, I will observe that, but you should always avoid taking liberty. Yes. You must understand that is an indefeasible right.
Yes, because
can I restrain you?
Yes,
can I restrain any citizen from approaching the court, seeking the redressal of the grievance that regarding this timing? I have some difficulty.
Yes, no, see, because
most likely,
I'm an assistant professor.
Sir, apart from sir submitting, also listen, sir. This is a dialect.
Yes,
this is a dialogue, sir.
No, sir, give me liberty.
Most likely, you have not brought to the notice of the court.
Yes, sir. Liberty,
otherwise, if you would have shown me, then I would have observed something. But since you are not showing anything that you brought to the notice of the court, okay.
as because Lordship, I am a assistant professor in Sahoo University. So my time period is very because court has already passed Lordship and only time the child to video call, phone call on each only time Saturday in between 8 p.m. to 8:30 p.m.
Sir, you are still you have not understood what I am saying. Where did you say before the court?
No,
That these are the conditions to be set. That I want to see, but you are struggling, sir.
You give me liberty Lordship to file the application before the family judge Bhubaneswar Lordship.
So the child is in custody of whom?
Myself Lordship. In my custody.
It cannot be in you, sir. Sir, husband, wife, by your client, sir.
My client,
So are you sure that it is with the lawyer?
My client is your wife, Lordship. I am
Darshana is wife. This is not, it could be Darshana also. Once I did that mistake, he, and so the wife is working in a Sahoo University.
Sahoo University. Assistant professor.
Sir, have you indicated these things in the writ application, sir? Any feelings to that?
Yes, Lordship. It's Lordship, page 6, last paragraph, Lordship, bottom paragraph, Lordship.
And sir, apart from one more, sir, it is more kind of advisory. It's I can't dictate that. Whenever you are getting these kind of matters, please advise them.
Yes.
For everything, there should not be issue. Suppose you are happy that you are meeting at 7 or 6, or the husband is coming and attending the child.
Yes.
Sir, don't be very possessive about those things. You must understand that. But anyway, I am not observing those lines, but you have a duty also to counsel them. It is very important. Yes. Kindly take your seat. I'll take some time in dictating. The petitioner wife is wife and mother. Petitioner wife and mother is before this court. Stop. The opposite party is the husband in the marriage. Other challenge is the order dated 12/12/2025, passed by the learned judge, family court. टिश्यू पेपर आने टिश्यू पेपर इट रहनी देखो गोटे टिश्यू पेपर भी आने पॉकेट रे टाइप अच्छी अच्छी द बसंत under challenge is the order passed by the learned judge family court in CP number 36 of 2025 dated 12/12/2025. The CP was filed for custody. CP was filed seeking custody by the opposite party, husband, father in the marriage. Opposite party, husband in the marriage, father of the minor child. Who is now aged about 6 years.
5 years.
26/10/2019 रे 26/10/2019 डेट ऑफ बर्थ लिखंतु देन यू आर सबमिट व्हिच इज अबाउट 6 years किते 26/10/2019
6 years
1925 एमटी हिसाब करा जाए मुझे तो डाटू छे आई एम लुकिंग एट एंड कैलकुलेटिंग एनीवे बट गुड दैट यू आर अटेंटिव कौन लिखने व्हिच इज अबाउट 6 years तो सेंटेंस से कौन लाए पहले Right. The present order involved in this challenge was passed in the IA. Granting interim custody and vegetation rights, interim custody as well as vegetation and contact rights to the father. Stop. The learned counsel for the petitioner mother was heard at some length. Stop. It is fairly submitted by the learned counsel for the petitioner that regarding interim custody, you can throw it, no problem. You can throw the pan because you should never swallow. You should never swallow the jarda. That is very important. I am always reminded of a senior advocate who used to tell me this. The mother doesn't have the mother doesn't have a grievance, but regarding the timing and other aspects like the days, public dates on which the father will have vegetation with the minor child, the mother has some difficulty as she is a working lady working as assistant professor in Sahoo University. Mr. Gopal Misra, I'm sorry, I could not immediately recollect. Gopal Misra. So he used to always quote one of his good friends. He studied in Ravenshaw. So he had good friends in those days. Only difficulty. Yes, you are currently working as assistant professor. Her duty hours as well as availability would come in the way as the minor, as the child being aged about 6 years. Now it is relevant. As the child being aged about 6 years remains with her and also requires her constant care and attention. Stop. In view of the limited grievance that is raised in the writ application, in the present writ application, the writ application is disposed of without issuing any notice to the opposite party. Stop. In considered view of this court, the opposite party, who is the petitioner in the CP as well as in the IA, would not be prejudiced also in any manner. The petition is disposed of observing that the present petitioner, if so advised, shall approach the learned judge, Family Court Bhubaneswar, Family Court Bhubaneswar, by filing appropriate application, bringing into the notice of the court regarding the difficulties that is faced. So the learned court shall deal with the same in accordance with law after giving due opportunity of hearing to all the parties. The writ petition is disposed of. Urgent certified copy as per rules. Yes. Yes. Next, please.
11.
So that's
Time, my lord. I have to file the annexation correctly.
Please. You want adjournment? Keep posting kar diyo tu?
No.
We commencing now, do we chalo?
Okay, sir.
Okay. Yes. Or you want further time?
No.
We commencing now, do we kar diyo? Yes.
Item 12.
Mr. Prafulla Ratha, senior advocate, along with Mr. Subham Agarwal and Ms. S. Das for the petitioner. You have instructions to appear?
Yes, let's.
She will be assisting me.
Let's. I have a Wakalatnama of my name.
We filed it in the registry spreadsheet.
You are Mr. Agarwal?
Okay.
Okay.
They all will be assisting me.
So since spread over, so that is how I thought that.
There is a reason to believe that but the points which
The
I get.
appearance memo of the learned senior advocate shall be filed in the registry. Same shall be taken on record. Scanned copy be updated.
That's the point which I'll be urging before my lords while challenging the entire certificate proceeding. Very first point would be the certificate proceeding initiated against a dead person. It's a mining lease. Dues were there against my grandfather. We are the grandchildren. Dues are, they say that against our grandfather T.B. Lal. T.B. Lal expired in the year 2008, leaving behind only son H.B. Lal. Now, my mother and H.B. Lal, they are separated, they are divorced legally. They are 2000, they are separated. Now,
is it the dispute over mining lease?
No. There is a matrimonial dispute.
No, so of course, the matrimonial dispute regarding the sharing of
not mining lease.
The products of the mining lease.
Family, maybe.
Okay.
13B divorce. So we,
by a decree
of the court. Now we are residing under the custody of our mother. Now, our grandfather died in 2008. Now, in 2018, the certificate proceeding initiated against the name of our grandfather. That your lordship will find at page 73, my lord.
The petitioners are the granddaughters.
Granddaughters of the certificate dater. Kindly turn to page 73.
But it is written, daughter of late Harshvardhan Lal, her father has also passed away.
Is our father.
Passed away.
He is also passed away. He is no more there. But the interesting point your lordship will see, but the point which I will be urging very interesting here, 73 your lordship may kindly turn to.
Page 73.
Right, my lord. Date katha lekha hai.
Annex 3.
Right, my lord. Order sheet date katha lekha hai.
66.
Kindly turn to page 70. Yes, page 79.
Yes.
Please. Page 79.
Yes.
Kindly see order dated 27/10/2018.
Yes,
You may see third paragraph. He expressed that the CDR is dead. Certificate dater is dead. So at least from 2018, you are aware that original certificate dater T.B. Lal is dead, and you have initiated this proceeding against the dead person. Am I clear, my lord?
Date of demise of the
2008.
8.
And you have initiated proceedings.
Yes, Mr. Who is appearing in this matter?
I am appearing, Lord.
And I will look at 79, sir. We have very little time, sir. Let us concentrate, be sharp on the point.
My senior is saying the irregularities in this initiation, whether a person is
He is not showing that. That is a legal infirmity.
Yes, yes, but subsequently it has.
And Mr. Sahoo, whatever you are submitting, I will be recording that. Like Mr. Samantra, so I will be recording that.
My respectful submission then will be the petitioner here challenging the notice under section 6 Miller. That is a notice on the legal heirs. Admittedly, they are legal heirs. There is no dispute over that. What I found. Whether they are liable or not liable, that is only the notice. Notice itself says whether if you are not liable, your lords may kindly see the notice also, which is under challenge, my lord. What is the language of this notice under section 6? That is the statutory provision initiated. Your lords may see page 9623. Here the notice is at 96.
Let me just correct my learned friend.
No, let him submit. So that is what I said because
yes,
Lord, I am
challenging 5 minutes.
I'm challenging the whole proceeding.
No, that I heard.
Right.
It is on record.
Right. So great.
Because otherwise you would not have gone to 27.
Right.
So
great. So grateful.
But he has liberty to say that he is not challenging.
Absolutely. I know that. I've said.
Please don't mind, Mr. Ratha, I'm cutting you short because only 5 minutes is left.
No,
please appreciate.
Doesn't matter. But I have only 1 or 2 points of law, that's all. I'm saying that.
First of all, but because you are demonstrating that
it's
I asked you the date. I don't know whether others are listening, but I pointedly asked you the date of date.
Right. The 2008, We are grandchildren. Like,
Yes, Mr. Sir.
Here, my response submission will be, even if there are other grounds my senior is taking, my lord. So far as the challenge of this notice, my lord, that is under a statutory provision. When there is a filing of this proceeding, my lord, the certificate officer is duty bound to send a notice asking whether you are liable or not, and that the language itself says that you are liable for summon. If you do not, if you deny your liability to pay such amount, then you have to give such reasons, my lord, and you so without filing any claim, what is claimed here, my lord, directly the petitioner has approached your lordship, my lord. So that is why my respectful submission is premature. And so far there is an appeal provision also under Section 60 of the OPDR Act. So far the grounds of
So your first submission is the notice is challenged.
Notice is challenged, my lord, after, and that is within their knowledge, my lord. At least
that challenge. Don't be so fast.
Yes.
I'm not as fast as you. You are just leaving me behind.
Yes, my lord.
Notice is challenged.
This is challenged. Which
immature, whether you immature, then second, and don't stick to a point. Only 5 minutes now left.
A provision of appeal is there.
Appeal is there. Appeal against which order? Against notice.
Against this original order passed in the OPDR case. Section 60, my lord.
Appeal against
any order.
Sir, kindly don't confuse. Appeal against which order you are saying? Order, you specify the order.
Order.
Annexure.
Annexure that 23. That annexure 23. That is notice, my lord.
Notice that is this is.
23
against annexure 23.
23 is the notice, and there is a provision of appeal against 23.
Annexure 23.
Yes, my lord.
The order dated 3/11/25.
3/11/25.
Yes, anything else?
And so far as they have been given an opportunity, and the matter is adjourned on their request to a subsequent date, which has not approved.
Who has given opportunity?
The petitioner is themselves.
Sir, don't say in abstract. Please be specific. Opportunity given by whom, by in which proceeding, which order?
They have
which order you say that opportunity
they have given. Petitioners have appeared before the OPDR court.
Sir, let us please, sir. Don't make a speech. Which order you are referring? That opportunity is given. Which is that order? Which page?
Yes, that.
Similar order. No, Hon'Ble Court's order. That leave this, no, the other one. Yes,
Order it as page annexure 20 is the order, and the matter was 12/12/25, 6, my lord. And so far as aberrament in the writ petition, I found, my lord.
Aberrament, no, sir. Your submission is that they were given opportunity which they have not availed. That is your submission.
Yes, that is also page 15.
Granted opportunity by which order? So kindly show the page.
Page 15, your lordship may see. Page 15 of the writ application.
Order passed by?
Page 15 is the admission, my lord, their own aberrament in the writ application. That's where,
sir, how can they give themselves opportunity, sir?
they have.
Kindly then you have to replay and listen again. You are saying that they were given opportunity which they have not availed. So who has given them opportunity when? By which order?
Your lordship may see page 15.
This is seen definitely.
Yes,
I say that 5% lordship may see what I can.
6 to 9/1/20.
Sir, who gave opportunity by which order?
Certificate officer, my lord.
By which order, sir?
Order dated 9.
So much time we are taking. Sir.
Yes,
Opportunity was given by certificate officer.
Yes, my lord.
By which order?
Posting the date to 9/1/26.
Which order, sir, you are referring?
9/1/26. So then detailed order is not there. All the orders have not been enclosed.
But you know it, so you have to tell.
Yes.
I can which order, sir? Kindly say that order. By which order? Date?
No,
or page?
3/11/23. Your lordship, see the impugned order itself is posted to 15/11/25. Date is fixed.
Sir, kindly say the date, order, authority.
Order dated that 3/11/25.
Dated 3/11/25.
The matter is
23. They were given opportunity.
They are given
Opportunity
of filing the reply, my lord. And the matter is posted to 15/11.
Yes.
Thereafter, it matter was posted to 9/1/26 and 17/1/26 on their request.
Yes.
And the matter is finally posted to 31/1.
Sir, did I ask you, sir? The matter is not posted, sir.
That is
Simply, sir, you are giving that, you are saying, or opportunity is given, they have not availed. Yes. Now, that is your submission or anything else?
My preliminary submission.
Yes, Mr. Rath.
The issue involved here, in fact, is pending before your lordship, and your lordship has been pleased to decide, pass an order, pending with the order. I have been. But identical issue with regard to dead person and with regard to substitution. But proceeding, दोनों ने order टा दी थी ना? अरे order टा दी थी आगे. The kindly similar, involving almost identical issue. Your lordship has been pleased to.
These are all your pending matters.
Right, yes. And your lordship has been sessioned over these matters involving almost identical issue. Lord, whether a proceeding can be initiated against dead person.
No, these I have noted the submissions.
Yes.
Yes.
So these are the matters pending before your lordship. Lord, 1, 2. Lord, once initiated against dead person, the law is you cannot substitute them. Your lordship, see 98 Supreme Court.
Dead person, any citation you have got?
Yes, Lord. 98 Supreme Court. Once, if it is initiated against a dead person, you thereafter cannot substitute. So thereafter. Lord, my second submission would be kindly similar.
98 Supreme Court page?
Lord, 98 Supreme Court, 98.
You have given it. Yes.
98, 5 SCC, 567. Lordship put straight to a turn to
SCC.
para 9. No?
7.
Para 7 and 9. Kindly see para 9 straight to him, Lord. In these circumstances, we are unable to uphold the impugned judgment of the High Court. In our opinion, executing court has rightly taken the view that the suit having been filed against the dead person, the decree was a nullity and could not have been executed. Appeal is accordingly allowed. And your para 7. In the present case, AC Basu proprietor Ashok Transport Agency has died before the institution of the suit. And on that date of the institution, the proprietary concern was not in existence. Only the legal representative of AC Basu could be sued with regard to any cause of action arising against AC Basu in connection with properties. We find it difficult to understand how the provisions of Rule 4 of Order 30 CPC could be extended to such a case. So there is no scope for substituting a dead person after instituting it in the proceeding. That is 1. 2. But it's a case you are initiating against the grandchildren. But if you see section 51 of OPDR Act IDC, you will have to show motor inquiry as to whether the property of the deceased has come to the hands of the legal representatives or not. That is absolutely section 51 of OPDR. Kindly see. Proviso to section 51. This is a peculiar case where you are initiating against the legal representative of the deceased certificate debtor without any inquiry, without any observation that any of the properties of the deceased grandfather have.
But let us not go at length into the merit.
Correct.
Yes. And this is
They are all arguable points.
This is Miller direction to the Honorable Apex Court order in the common cause. Miller.
Sir, kindly show that order. Kindly show the order where the Supreme Court has directed to initiate against dead persons.
That is the outcome of this order, Miller. The order itself reflects, Miller.
Sir, kindly show the Supreme Court order.
We have reproduced. That's fine. Well, my lord is asking where is the order to recover against the dead person?
No, Supreme Court order, that soft copy I have not got the hard copy. But the order reflects.
The order which I have read and I remember. Or you, the order which this batch of
No, I am not going to that, Miller.
The Sahoo, you have to listen to understand.
WPC 100.
So you are not listening, sir. That's the problem.
Yes.
By which order Supreme Court has directed to initiate this OPDR proceeding, you are saying.
Yes.
So I'll also record that.
You'll also page annexure 3, there is a reference.
The Supreme Court order can never be annexed. You tell the order and the party name and the.
To get that
Supreme Court order, sir.
Yes, Supreme Court.
Annexure 3 Supreme Court order.
So there is a reference. There is a difference.
We have indicated. The Supreme Court has simply said.
Sir, not WPC order.
I am not just now. I am not having.
So then please don't be careful because you are live. You are recorded. I will also be recording this. I told you.
That is the order.
I am just recording your submissions so that I am straight time. Mr. Zappa, can I record his submissions? I mean, I will record your submissions later. I have already overstood the time.
Right, Lord, your lordship.
Yes. It is in response. It is submitted by the Learned Counsel, Learned Additional Standing Counsel, for the appearing for the opposite parties that the OPDR proceeding was initiated pursuant to an order passed by the Honorable Apex Court. You take your seat. I'll take some time because I have to complete this your submission. initiated by the OPDR proceeding was an Honorable Apex Court. As a natural response, the Learned Counsel was requested to show the order and the details of it. In response, he submits that immediately he is not having it, but prima facie, the authorities acted upon based on a Supreme Court order, direction of the Supreme Court order.
That is at Annex 3.
He refers to Annex 3, which the petitioner has not annexed any, whereas the petitioner has not annexed any Supreme Court order. Juniors, you should be ready on your, these are the questions. Even if after preparing for 10 days, you will always expect a question from the court which you cannot answer. That is my experience. I tried to prepare, but you are not, I mean, you should brief the senior like that. In such scenario, this court is unable to refer to any Supreme Court order where there is direction to initiate proceeding against the present petitioners. It would be suffice to note that as referred by the Learned Additional Standing Counsel, the Annexure 3 refers to Annexure 3 discloses the following. In inviting a reference to subject cited above up to OPDR Act. Annexure 3 reproduce कर दे. In invite a reference to नहीं की. ताले पूरा ना scan करी reproduce कर दे. पर it is submitted that the petitioners have approached this court at the stage of notice. Therefore, it is premature. A statutory appeal under which provision?
60 of the
under
60 of the OPDR Act.
Under section 60 of the OPDR Act is available against the Order Act Annexure 23 dated 3/11/2025. It is submitted that as it would be evident from Annexure 23 that opportunity was given to the petitioners which they have not availed. It is further submitted the petitioner, instead of replying to the notice, have approached this court, which cannot be sustained. Petitioner का commission टा कल sum up कर दियो तो proceeding initiated against a dead person. Order dated that order page 75.
Right. That is at page 79.
79. Page 79.
Yes, President.
The petitioners are granddaughters of original lessee.
Yes.
Who is deceased since original lessee died in
2008. Date is not
2008. The petitioner's father died in Harshvardhan Balal
2024. 3rd of April 2020. 3rd of April.
3rd of April 2024.
What is that inquiry?
Section proviso to section 51 of the OPDR.
Yes.
Short points लिख दियो 1998 5 SCC 567 para 7. So let us meet in the
Can I refer?
other part of the building. Sorry.
Yeah, can
Please,
I-
anything I
One
Yes,
just,
jaldi.
one just annexure, annexure 2 page 64.
Annexure, you give me the pages. Annexure 2 page
Page
64.
64.
Another page.
That is
79 gote.
That is 79.
79, 64.
That's all. 64 says that we have not inherited any property from our land. That's the admitted document.
Yes. But I mean, sorry.
I understood. I understood.
Stay.
So grateful.
Stay.
Thank
Stay.
Order take. You take it, Joe.
Recording stopped.